Hello and welcome to Courts Today by Live Law. I am your host Urvashi Chauhan, here to keep you informed with the latest and most important updates from the legal world. First, we will cover the top headlines, followed by an in-depth look at each major update. The Supreme Court has asked the Delhi government and police to explain steps taken to enforce firecracker ban in wake of the all-time high pollution in Delhi NCR. A West Bengal court has framed charges against Kar rape murder accused Sanjay and the trial is likely to begin next week. The Supreme Court has relaxed bail condition that journalist Siddique Kappan should report at Uttar Pradesh police station every week. The top court has adjourned Balwant Singh's plea to commute death sentence in the Punjab CM assassination case, saying that there will be no interim relief without hearing. Central Bureau of Investigation has moved the Supreme Court against Karnataka government's withdrawal of the consent for probe against Deputy Chief Minister D.K. Shivakumar. The Apex Court has observed that Domestic Violence Act meant for quick remedy, but the cases drag on like other family court matters. The top court has dismissed a plea which sought hearings at the Supreme Court in Hindi. And the Punjab and Haryana High Court has sought response from the Union and Punjab government as to why only 2 international flights are there from Chandigarh Airport. As with previous winters, pollution levels in Delhi have reached an all-time high, with the air quality index surpassing 400 in Delhi and 315 in Noida. You are aware that the Supreme Court is hearing the MC Mehta case concerning air pollution in the Delhi NCR region from sources such as firecrackers, stubble burning, waste burning, vehicular emissions, industrial pollution, etc. During the hearing today, a bench of Justices Abhay S. Oak and Augustine George Massey directed the Delhi government and the Police Commissioner of Delhi to file affidavits stating steps taken to implement the ban on firecrackers in Delhi, as well as proposed steps to ensure compliance with the ban next year. The court observed that there was little dispute over the fact that the ban had been poorly enforced. It noted that the effects of this lack of implementation were evident in the report of the Center of Science and Environment, which indicated that Delhi's pollution levels during Diwali 2024 had reached an all-time high, surpassing those of Diwali 2022 and 2023. Additionally, the report highlighted a rise in farm fires during the Diwali period. The court further asked the authorities to take a call on a perpetual ban on firecrackers in Delhi, proposing to extend the ban beyond Diwali to other festive occasions as well, but first to see the nature of the present ban order. Referring to the report by the Center for Science and Environment, amicus curiae Aparajita Singh pointed out that farm fires significantly increased during Diwali, with recorded incidents spiking from 160 the day before Diwali to 605 on Diwali day, rising the pollution levels. She said that the pollution percentage increased from 10% to 30% on Diwali. Further, the court directed the government of Haryana and Punjab to submit affidavits reporting the number of stubble burning incidents during the last 10 days of October. If you remember, the court had earlier expressed concern over the lack of penal action by the Commission for Air Quality Management and the state governments of Punjab and Haryana in curbing stubble burning, which the court observed as a violation of the fundamental right to pollution-free environment under Article 21. Today, the court also inquired about the progress of setting up of the necessary machinery under Section 15 of Environmental Protection Act. The Council for the Union informed the court that draft rules have been prepared and are currently undergoing translation, with completion expected within 2 weeks. The court also ordered that an updated compliance report be filed by 14th November. In the next update, a West Bengal court has framed charges against Kar rape and murder accused Sanjay. Roy has been remanded in custody as a suspect in the brutal rape and murder of the trainee doctor at the Medical College and Hospital at the end of her night shift. The court has also stipulated that the trial will commence on 11th of November, that is next week. The gruesome rape and murder of the trainee doctor led to nationwide unrest. There were protests across the country, including by medical professionals, demanding better safety conditions at workplace. The Supreme Court, as you are aware, took suo motu cognizance of the issue and emphasized the need for enhanced security for medical professionals as well as improved conditions at workplace. The investigation of the case was handed over from the state police to the CBI by the Calcutta High Court. The CBI found Roy to be the sole accused in the case, while it also arrested former principal Sandeep Ghosh over his alleged complicity in the crime. The Supreme Court today relaxed the bail condition imposed on Kerala journalist Siddique Kappan that he should record his presence at the police station in Uttar Pradesh every Monday in connection with the alleged Hathras conspiracy case. Kappan, who was granted bail after 2 years of incarceration, was arrested along with other accused by Uttar Pradesh police in October 2020 while they were proceeding to report the Hathras rape murder crime. While initially he was arrested under the apprehension of causing a breach of peace, subsequently he was booked under the UAPA, alleging that he and his co-passengers were trying to incite communal riots and disrupt social harmony in the wake of the Hathras gang rape murder case. Another case is also pending against him, where he has been accused under PMLA by the Enforcement Directorate. The Supreme Court had granted him bail in September 2022 in the UAPA case with a number of bail conditions imposed. Some of them include requiring him to deposit the passport, to not leave Delhi without the permission of the trial court, etc. He had sought relaxation on one such condition, which required him to record his presence at the police station in Uttar Pradesh every Monday. A bench of Justices P.S. Narasimha and Sandeep Mehta has now allowed the application in this regard. The top court today deferred the plea filed by Balwant Singh Rajwana, who is a Babbar Khalsa terrorist and a death row convict. He was convicted in the incident involving a bomb blast in the year 1995, wherein the then Chief Minister of Punjab, Bengal Singh, along with 16 others, lost their lives. He has sought commutation of death sentence on grounds of extraordinary delay of 1 year and 4 months in deciding his mercy petition, which is pending before the President of India. His petition also sought consequential release on the grounds that he had undergone a total sentence of 28 years and 8 months, of which 17 years have been served as a death row convict in a capital punishment cell, including 2.5 years in solitary confinement. A bench of Justices B.R. Gawai, Prashant Kumar Mishra and K.V. Vishwanathan had issued notice in his petition in September this year. Justice Gawai today questioned Punjab's counsel if they had submitted a reply to the notice issued. The counsel explained that they could not file it due to vacations. Justice Gawai then allowed 2 more weeks for Punjab to file the reply. Senior advocate Mukul Rohtagi, representing the petitioner, requested interim relief in the meantime, but Solicitor General Tushar Mehta strongly opposed the request. The court stated that they would only consider for relief after having heard the matter. Accordingly, the hearing has been now postponed to 18th November. In another update, the Supreme Court was today informed that Central Bureau of Investigation has filed a special leave petition before it, challenging Karnataka government's withdrawal of consent for investigation against Congress leader and Deputy Chief Minister D.K. Shivakumar in the disproportionate assets case. In August 2017, the Income Tax Department raided Shivakumar's premises, seizing 8 crores, leading to cases under Income Tax Act and PMLA and resulting in his arrest in 2019. The Karnataka government later gave permission for a CBI investigation. Both the High Court and Supreme Court at the time had rejected Shivakumar's plea to quash the case and the investigation. However, after the Congress took power in May 2023, the Karnataka government withdrew its consent for the CBI probe in November 2023. So the CBI and BJP MLA BP Yatnal approached the High Court to challenge this, but their petitions were dismissed by the High Court. Thus, they have now approached the Supreme Court. In September, the Supreme Court had issued notice and questioned whether Article 131 of the Constitution, which deals with disputes between central and state governments, applied to this case, and remarked that it was ideal to resolve the matter on its merits to avoid creating suspicion about the case's legitimacy. Today, when the bench of Justices Suryakant and Ujjal Bhuya was hearing another plea challenging the withdrawal of consent filed by BJP MLA Yatnal, SG Tushar Mehta appraised about the filing of CBI's appeal. The SG urged that both cases may be listed together. Accordingly, the matter has now been listed after 4 weeks with an indication that CBI's plea will also be heard on the same date. The Supreme Court today expressed concerns at the slow pace of progress in cases under Protection of Women from Domestic Violence Act 2005, saying that they are moving like regular family court cases. The bench comprising Justices B.V. Nagratna and Pankaj Mithil was hearing a petition filed by the NGO We the Women of India, in which it had earlier issued directions for effective implementation of the Act. Senior advocate Shobha Gupta, representing the petitioner, submitted that there is an assistance network formed in the Domestic Violence Act, which includes protection officers, service providers, shelter homes, and medical facilities are there to assist women in need. However, the data collected by them reveals that in many states, protection officers are appointed while on additional charges. She also referred to the affidavit where the union government mentioned Mission Shakti and one-stop centers. Gupta averred that they had called some of the one-stop centers and their response was not very satisfactory. Additional Solicitor General Aishwarya Bhati then interjected and informed that an updated status report would be placed on record. The court observed that though the Domestic Violence Act was supposed to be a quick remedy, the cases filed under it are being dragged on. Justice Nagratna was of the view that states need to be impleaded as parties as they are in charge of appointing protection officers. The court will now hear the matter on 2nd December. It observed that prayers made in the petition are omnibus and directed the petitioner to file a common application which should include suggestions from the Union of India on specific directions sought from the court. In another update, the top court today refused to entertain a PIL challenging validity of Article 348 Clause 1 of the Constitution. This article provides that all proceedings in the Supreme Court and all high courts be done in English language. The petitioner sought hearings in the apex court to be in Hindi. The bench comprising CJI D.Y. Chandrachud, Justices J.B. Pardewala and Manoj Mishra was hearing the matter and asked the petitioner as to why only a specific relief for the Hindi language was sought in the PIL, considering that matters to the top court are filed by parties belonging to all diverse states of the country. It was further pointed out that the provision under challenge has been part of the original constitution. The petitioner argued that the linguistic barrier in the Supreme Court leads to denial of access to justice. But the bench, disinclined to entertain the matter any further, dismissed it. And lastly, the Punjab and Haryana High Court has sought affidavit from the Ministry of Civil Aviation and Punjab government on why there are only 2 international flights from Chandigarh International Airport on daily basis, that is to Sharjah and Dubai. Chief Justice Sheel Nagu and Justice Anil Kshetrapal said that there was no explanation coming from the Chandigarh International Airport Authority Limited as to why there are only 2 international flights from Chandigarh, which is a union territory and capital of 2 prosperous states, when even a district headquarter like Amritsar has more than 14 international flights to various countries. It also sought an affidavit from Punjab government explaining as to what steps have been taken to increase the number of international flights from Chandigarh International Airport. These observations, let me tell you, were made while hearing the writ petition filed on the non-operation of international terminal, stating that the same is causing huge loss not only to public exchequer but also to passenger services and business situated in Punjab, Haryana and Himachal Pradesh. Previously, the court had also delved into the issue of shorter route to the airport. A committee headed by Additional Solicitor General of India S.P. Jain was constituted, which was directed to submit a timeline for ensuring expeditious completion of the proposed shorter route. However, the timeline for construction of alternate route is still hanging fire and has not been submitted till date. In this regard, the court has also directed the Secretary, Ministry of Civil Aviation, Government of India to provide a certification as to whether there is any plan for extending the airport, and if yes, then on which side of the airport. The matter is now listed for 6th November for further consideration. For more details on the cases mentioned here, you can visit our website at www.livelaw.in. Stay ahead with quick legal updates only on Live Law. Do not forget to like, share and subscribe to our channel. You can support us by donating through the thanks button at the bottom of our videos or by becoming a member for just 89 rupees per month.